Hello and welcome to another episode of the Pastor's Legal Bootcamp. I'm your host, Joel Beck. I'm an attorney with Peach State Wills and Trust in Lawrenceville, Georgia. And this video series was designed for pastors and clergy and other spiritual leaders. When you're facing a situation with one of your congregants or a community member that you may deal with some other issues, including spiritual issues with, but it overlaps or intersects with some potentially serious legal issues as well. And our goal with this video series is to give you a very high-level overview of some information that you ought to know from the legal perspective that just may help make sure that you spot some legal issues that might need to be addressed and maybe give you some resources to recommend for that person as well. Now, typically in these videos, we're sitting here in my office and I'm interviewing another attorney and we're talking about legal issues relating to their practice area. But today, we're going to cover an important legal issue that deals with what we do here at my firm, things that I work with on a regular basis. Here at Peach State Wills and Trust, we work in the field of estate planning and probate. And today, we're going to talk about some legal issues that arise as a result of a terminal diagnosis. So you might have a congregant or a community member that comes to you for help and support and spiritual guidance, and they might tell you something along the lines of, the doctor told me it's stage 4 cancer and I need to get things squared away, or the doctor said it's terminal and I need to get my affairs in order. Now, of course, that might raise some spiritual concerns for them, but definitely you can see how easily that raises some legal issues as well that they may need to address as they navigate the journey to come. And when we think about this from a legal perspective, there's really two things that we want to ensure are addressed. The first is, what happens if I'm incapacitated? Who's going to be able to manage things for me, take care of things? We need to address that incapacity planning. And then on the other hand, the second issue to deal with is what happens when I pass? From the legal perspective, what happens with my assets, with my bills, everything else? What do we need to do? And so this is where we come in. Unfortunately, we do have clients that come into us with that same type of sentiment that the doctor said, I need to get my affairs in order. And we're going to sit down and have a conversation with those people about those two issues. How do we deal with things if you're incapacitated? And then what do you want to see play out upon your death with respect to your estate? So let's talk briefly about those two things to give you a high-level education on how this works here in Georgia. For any folks that might be watching from other states, while I hope that the video series might be helpful and informative, the legal things we're talking about here, while the principles may be somewhat similar or the same in other states, we're really talking about how we do it here in Georgia. So with respect to incapacity planning, you have somebody with a terminal condition, they have a real serious medical condition, there's certainly the possibility that they may lose the ability to manage things themselves. And there's some stuff that we want to make sure that they've got legal plans in place so that the right people, the people that they trust, have legal authority to take care of some things. And what we're talking about here first is health care. All right, if the person can no longer make medical decisions for themselves, if they lose the capacity to do that, either because of problems with dementia, memory impairment, in a coma or reduced state because of a condition or medication even, we want to make sure that person has somebody with vested legal authority able to speak on their behalf. And so in Georgia, what we're going to typically do is complete an advance directive for health care. The advance directive for health care combines into one document some things that other states may do in two, and that would be a living will and a power of attorney for health care. So Georgia's advance directive for health care lets you designate who should make medical decisions for you if you can't do it yourself, and you can also list a backup or two, and then it's going to spell out how you wish to be treated in a couple of situations that are somewhat common for end of life. such as if you have a terminal illness that's going to result in your death shortly, or if you're in a permanent comatose vegetative state, how would you want to be treated? Would you want to be hooked up to machines and medications and have procedures done simply to extend your life? Or would you say, my preference is maybe let me go, but keep me comfortable. Don't do things that only extend my life but can't cure me. So those are some treatment options and preferences that a person can designate on their healthcare directive, while they also give authority to a trusted person to be able to make those medical decisions if the person can't do that themselves for whatever reason. Now, a healthcare directive is not a DNR or a do not resuscitate order. A DNR is not something that people are going to do with us, with lawyers. That would be something that they would do with their own doctor, and the doctor can sign off on that as well. And for somebody asking or considering maybe a DNR, that is something they want to address with their medical doctor. But in addition, they're going to want to make sure that they've got the healthcare directive in place, appointing the right folks with authority to take care of things. So that's the first part of incapacity planning. The second part we want to deal with is really managing everything else. So anything that's not healthcare. And so this would be our money, our property, our personal business affairs, the ability to fix up the home, to fix the leaky roof, to manage the money in the bank or the retirement account, to renew the car tag, and to pay our taxes and deal with Social Security and insurance. All of these personal financial and personal business affairs, we want to make sure that there's a way that those can be managed if the person is incapacitated. And a typical starting point for this is a durable power of attorney. And this lets you designate somebody to be your agent, to essentially act as if they're you, to be able to manage your money, your property, your personal business affairs. And you might name a principal agent, and then you can name a backup or two, and you get to articulate which particular powers the agent has, what they can and can't do through this. Now, Georgia had some significant changes to its power of attorney laws back in the summer of 2017. And if somebody has a power of attorney in place prior to July 1, 2017, we would say they really ought to look at getting it updated so that it comes into the new law, because it's more favorable for these documents to be dealt with under our newly revised Uniform Power of Attorney Act. Even then, if somebody's done a power of attorney, maybe they got a form off of the internet or did something online or what have you, or used an old copy of something, but they've done it recently, I would say get that looked at by a estate planning attorney to make sure that it's going to actually do what you want it to do and that it can be enforced. The law has some very specific requirements on how these need to be prepared, what type of form, how it's executed and witnessed, and the like. So we want to make sure that's good to go. So those are what we think of when we think about incapacity planning, the healthcare directive, maybe a DNR with the doctor to deal with the healthcare things. But then for everything else, money, property, personal business affairs, we want to make sure there's a good, durable power of attorney in place. Then we turn to the what happens next moment. And this is what people often think about when the doctor says, hey, get your affairs in order. We're talking about what happens when you pass away, when they decease, where are things going to go, who's going to be in charge of that process. And so in Georgia, we essentially have two different tracks that you can follow. We can use what's called a will-based plan, or we can use a trust-based plan. Both of these can do a job of distributing your assets when you pass and setting forth who's going to be in charge of that. Which one is better is going to be subjective, and it's going to be based on your situation, your wishes, your goals, etc. With a will-based plan, most people are familiar with a will, and the will says, I'm leaving things to these people. This person is going to be my executor. This person will be the backup. A will is going to pass through the probate process. So when the person dies, the will is offered for probate. It's going to go through that process, which means the estate is not going to be settled immediately. The probate process will probably take at a minimum 6 months. It could be a year or longer, and there could be complications with that in case people in the family are going to fight over, is this the will? Did they have capacity to make it? Who should be the executor? And the like. Importantly, not everything passes through a will. There are going to be some things often that people have that are considered non-probate assets. An example of that would be an asset that's jointly owned with somebody else, or would be an asset that has a beneficiary designation. So think of an IRA or a 401k account or a life insurance policy where you list who the beneficiaries are, meaning that when you die, the custodian of that asset will just pay that out to the people or the persons that you've selected on your beneficiary form. Wills go through probate. Not all of the assets that a person have will necessarily go through that probate process. The other approach, other than a will, would be to use what we call a revocable living trust. And these are growing in popularity in Georgia, widely used in many other states that I would say are not as probate friendly as Georgia is. But as the population here grows, as the probate courts become more crowded, I think we're seeing revocable trust be used more and more now. But essentially what a revocable trust is, it is a suitcase to pack your assets in. It's a way to organize your assets in your life so that if you become incapacitated or you pass away, a successor trustee, somebody that you've picked and specified in the trust document, comes in and picks up the suitcase or picks up the trust and continues on and manages things that are in the trust if the principal is incapacitated, or if they've passed, then follows the terms of the trust to pay off your bills and then distribute the assets. Both approaches can be effective. Which route ought to be used is going to vary in case to case based upon the principal's wishes, their goals, their objectives, the complexity of their wishes, as well as how they're holding their assets now. But those are really the two approaches, and certainly one of those approaches ought to be adopted and have a good plan put in place, a well-written plan that meets the requirements of Georgia law when somebody is told to get their affairs in order. So that's a pretty high-level overview of some legal issues that come into play when you might sit down to talk with somebody who has that very serious spiritual concern as well of a terminal diagnosis, of the doctor telling me to get my affairs in order. I hope you found this helpful and informative. If you'd like to go a little bit further and get some additional resources on estate planning here in Georgia, I would tell you to go to our website at peachstatewills.com, click on free info at the top, and then estate planning resources. You can put in a name and email address, and our system will email you automatically our guide to estate planning in Georgia. It will walk you through in a little bit more detail several of the legal documents, planning documents, and tools that we just discussed earlier in this video, and it will answer a lot of the frequently asked questions that people have. Certainly you can share that resource with others or point them to our website where they can download this. If you or somebody else needs more information, we would invite you to call us at 678-344-5342 or go to peachstatewills.com. You can click on the Contact Us and send us a message that way. We'd love to be able to be of help if we can. Be sure to check out the other videos in our Pastor's Legal Bootcamp series. peachstatewills.com, click on free info and then Pastor's Legal Bootcamp. Also, you'll find the videos on our YouTube channel as well. And check back from time to time as we seek to add additional videos from other legal subject matter area experts that may be able to be of help and a resource to you. Thanks.